Hello, and thank you. Thank you very much for listening to today's episode. I know why you're listening. Well, we're almost there. Here's where we're at. We're very, very close. The news is almost all good. Maybe it is all good. We left with me saying that my attorney turned out to have been the one who... Well, why don't we go to the beginning? Hello, welcome to the Depuy Pinnacle Litigation Update Podcast. I'm your host, GF, and I'm also your engineer today. So if there's any mistakes cutting the tape, as they used to call it, it's my fault. But to get back to where we were yesterday, and we're getting close. So it was my attorney's fault. It looks like, as much as I can tell, he had gotten the HIPAA form from my lender on either Wednesday or Thursday and had not gotten around to signing it, as we talked about, till Monday, yesterday. So I was blowing my top. And if you listened yesterday, you know that I told my attorney that unfortunately I had to go through his secretary because he wouldn't get on the phone with me. But I had told her she better tell him that he better not do that again, that getting me my money is job number one. And if he has paperwork on his desk that he has to sign to get me my money, he has to make sure that that's the number one thing he does and nothing else gets in front of it. And he is not to go home for dinner if he's leaving on the desk my money signature. He's to sign and go through it and sign it, and then he goes home for dinner. And that's what I told her. So let's see if we get a motion in the mail to be relieved. That's how a lawyer gets rid of you, but they will never do that. At least I don't think so. We've talked about this in the past episode, so if you want, go back and listen. But we've talked about how at least in California, if the attorney quits, I don't like this client, just screw him. He loses out on the contingent fee. He has no claim for fees. So they never quit on a contingent fee. So the point is, and I'm going to keep this real short today because we're sliding into home. The attorney yesterday did get the paperwork over to the lender. I was scared as hell because, what you don't want to hear is the lender saying, he just filled something out here. We didn't know that he's in tech or whatever. But I called them up and they were as nice as could be. And they said, yes, we just got the paperwork and you're ready to be funded. And I couldn't believe it. I said, oh, God, that sounds great. And he said, the money will be in your bank account Wednesday morning by 9 o'clock. And he said it will be in there by 9. You probably before that, but Wednesday morning by 9, you'll have the money in your bank account. Wow. Well, that was great news. I told him, God bless him. And I said, I have to tell you, I am an atheist, but still, God bless you. That's great. And that's what I really said, yes. And so it looks like, from what they've said, there's going to be money. And if there's money for me, I think there's money for you. Okay? So let's meet Wednesday morning. That's the 25th. Let's figure around 11 o'clock. You'll go to your usual spot, wherever it is that you listen to podcasts. And at that time, I'll go over with you who it is that lent me the money. And but that's how I've made sure that it's in my bank account and that it's cleared and everything like that it can't be reversed. And once it's solid in my bank account, I will post it and tell you, hey, here's where I am. I do have something that you can help me with. I think my email is hiplitigation, one word, hiplitigation @gmail.com. Why don't you tell me if you think I should tell the lender what we're doing? Should I tell the lender, hey, I've got a podcast, I have a lot, and I mean, I'm stunned when I see the number, a lot of really wonderful people who listen, and I thank each and every one of you. And And I thank the people who sent me emails as well. Thank you. Let's see if you people think that we should let them know in advance that I'm going to be revealing all of the details of our work here, or how many sorry about that, a horn honking outside. How many people here think that it's just better if we keep our mouths shut? Which a lot of people, that is the go-to plan. When in doubt, especially if there's money involved, keep your mouth shut, keep your eye on the ball, which is get the money, and don't get other people involved. Don't ask anybody else to get involved, and just instead find out what it is you have to do to get your plan going like mine. I'm going to tell you the things that are really, really important, what you want to do to fill out and get your request for an advance filled out as quick as possible. You want to have all of your information about who is your lawyer, what's his phone number or her phone number. You want to be, obviously you need your address and all that kind of stuff. This particular lender did not ask anything about what do you need the money for. They didn't care. They didn't ask. So we don't have to come up with any sort of explanation for that. But you do need to come up with the normal information about, where do you live, who is your attorney, what is the name of the law firm your attorney works for, what is their phone number. I'm very surprised none of them ever ask the case number, but none of them ever do. But you will need all that kind of stuff for your package, and we'll figure out where it is we're going to send it tomorrow when I can confirm that there's money in the bank. But it does look good. It looks like all of that panic that I did in the past episode was my usual assumption that everything is going to go wrong and it won't work out. And instead, it looks like you and I and all the other guys and gals, all the people here who are hurting from the Depuy Pinnacle can get a small, medium, an advance towards our case. Okay, I know you need it. I know you'd rather I get it out there today, but I am not going to be making any competition. Until I have my money, I'm not going to be sending anybody else in the door to say, hey, how much you got laying there in the pot? I think I'm a better source of funds than GF. Why don't you give it to me? You got a better chance of winning. That, of course, is what the secret is tomorrow. We want to package your presentation to them in the way that maximizes the chance that you're going to win. Because this particular company, I'm starting to let things out, only deals in the type of loans where there's no recourse, which means if they lend you the money and our case goes down the toilet, you don't have to pay them back. You don't have to pay anything back to them. And the companies that do that charge massive high interest fees. So those are both true. I'm going to tell you, and I told you this the other day, but there is a limit on what it is that I will owe them if the case goes on forever. But unfortunately, it is 4 times what I borrow. So if I borrowed $50, if that's what they're going to advance me, and it's not, but if that were it, then the limit is that I would have to pay up to $200 back. So keep that in mind, please. If there's anything I can help you with, if you have any questions about whoever this horrible loan company is, or not loan company, the lien company, please send me email. I'm happy to answer your email. Again, that's hiplitigation@gmail.com. Remember, I cannot give you legal advice because I'm not an attorney, and you are represented by an attorney. So it is totally against all the rules for me to be advising you in manners that your attorney should be advising you. So that's why a good 50% of the questions, you get back the answer that says, this is something you have to go over with your attorney. I suggest you make a sit down, go over it, and many times it helps to have them record the session and give you a written transcript so you can actually read later. Hey, who said what did he say about this and that? What did she say about, I mean the lawyer, what did she say about having to pay back this lien company? I'm going to tell you this. I've done a little bit of reading into it, not enough that I should be opening my mouth, but I'm just going to tell you that as I understand this company, because they are not out here and not operating in California, the service that they do of compiling the liens and putting them on notice to your attorney. In other words, and this is also awfully hard for me to believe, but I got, I think, 6 emails on the topic. So in sunny California, nobody could charge for that. That is considered part of the business of a hospital, keeping their records and keeping things and collecting their fees. They can hire an outside person to make sure that the liens are compiled and correctly served on the attorney, and to make sure there's no claim by the attorney that he didn't know about the lien and therefore he let the money go, which I never see happen. But the point I'm getting to is that that's not a fee that anybody can charge you for. Nobody can charge you for that, at least in California. That's just a part of the work of the hospital. They have to do that in order to keep in business. So they cannot do that. Somebody suggested, I think it's somebody who doesn't understand, but somebody said that this same organization then negotiates the lien on your behalf. No, that can't be right. What they're doing is they're negotiating the lien on behalf of the hospital. In other words, when the case settles and there's money in the pot, we're going to them and saying, okay, First General Hospital has a lien for the work you did on my hip for $51,000. We're going to settle it and pay you out of the huge $5 million verdict that we just got in court. Well, if that kind of thing happens, in other words, if the lien company we're dealing with, Provincial or whatever their stupid name is, if they are working on behalf of the hospital and they are settling the liens, in other words, they come to your attorney and say, we're negotiating the lien on behalf of the hospital, they cannot possibly charge you for that fee because they are actually acting as a collection agency against you. So nobody can charge you for that. I don't care what state you're in. If you heard of that, if you believe that's the case, please email me anything you have, and we'll go over it on the next session where I break the good news to you about, hey, my money was in the bank and it's time to celebrate. Nobody could charge you for that. But on the other hand, remember your attorney, and I've been in the middle of this, so I know this one for a fact. I got dinged on this one, where the attorney spends tremendous extra hours, maybe 20 or 30 or 40 hours getting the liens down in order to help one particular client. And I did that because he was a friend, and I ended up charging him, I think, $700 extra, and I got him an extra $30,000 by just going back and forth, and I did things like I said to one doctor, I said, I'll tell you what I'll do. If you'll accept half of what he owes you, I will go get it in cash right now at the bank, and I'll bring it to you. You give me a receipt, because we're declaring this, and I'll give you cash, and you can therefore da-da-da-da-da. And so I got my friend like an extra $30,000 out of his case. I charged about $750, and then he sued me for the $750, saying I can't charge for that. And the bar said that's correct. Settling the liens is part of the services that are expected of any attorney who is representing you, whether we look at this as a personal injury suit or as a medical malpractice suit. We try to talk